Right now, federal marshals are actively executing orders across multiple locations. Just moments ago, Federal Judge Eleanor Caldwell signed off on immediate arrest warrants tied to a bombshell leak now known as the Witness 14 recording. For the very first time in this entire investigation, a sitting federal judge has ordered people taken into custody based solely on recorded testimony that was never meant to go public. Inside the courthouse, sources describe total disorder. Legal teams rushing through hallways, electronic devices seized on the spot, and U.S. Marshals locking down every possible exit. This is not a routine filing. This is not another strategic delay. This is a federal judge declaring that what she heard constitutes direct, actionable evidence of major federal crimes, and she wants suspects detained before nightfall. So what caused such an extreme judicial response? It was a 47-minute audio recording from a protected source identified only as Witness 14. The tape surfaced online late Thursday night. Within hours, it spread uncontrollably, racking up more than 2 million downloads before platforms rushed to take it down. But by then, it was far too late. This isn't just another controversy in a case already riddled with problems. Legal analysts are calling this recording the missing piece, the evidence that turns suspicion into certainty. The tape allegedly contains direct, first-person accounts of coordinated criminal actions. Names are named, dates are specified, illicit transactions are described down to exact figures. And today, I'm breaking down exactly what's on that recording, the details certain people hoped would never be heard. What separates this leak from every other in recent legal history is Judge Caldwell's reaction. She didn't call for further review. She didn't set a future hearing. She verified the tape's authenticity and within 6 hours authorized arrest warrants. Former federal prosecutors say this kind of response is almost unheard of in modern U.S. courts. Even more shocking, the individuals named in those warrants were not fringe players. They include figures no one expected to see facing handcuffs. The marshals involved aren't state or local. They're federal, acting under direct judicial authority. So what exactly does the Witness 14 recording reveal? According to transcripts now circulating among senior legal analysts and investigative reporters, the audio captures a protected witness outlining a deliberate operation designed to obstruct justice. The testimony details evidence manipulation, witness intimidation, and coordinated efforts to derail the case entirely. This is the moment everything changes. Witness 14, whose identity remains sealed by court order, describes being personally instructed to destroy records, modify digital files, and align false testimony with at least 4 other individuals. The recording specifies dates: March 14th, April 2nd, and May 19th, and identifies 3 previously unknown co-conspirators. The witness also recounts cash payments totaling more than $340,000, allegedly distributed to silence potential witnesses. Experts who reviewed verified sections say the level of detail is staggering. This isn't vague storytelling. It's precise, it's methodical, and it's devastating. At one point, Witness 14 states, "I was told exactly what to say. They handed me a script. When I questioned it, they made it clear my family would suffer if I didn't cooperate." This wasn't witness coaching. Prosecutors say this crosses directly into organized witness tampering, conduct severe enough to qualify as racketeering. And then the recording goes even further. Witness 14 describes a meeting where evidence destruction was openly discussed, documents shredded, hard drives wiped, cloud backups erased, all while subpoenas were active and the investigation was ongoing. Former federal prosecutor Marcus Webb described the tape as the clearest recorded example of obstruction I've encountered in 3 decades. The reason? Specificity. The witness provides badge numbers, physical descriptions of meeting locations, verbatim quotes from conversations, banking details tied to alleged payoffs, even names of attorneys accused of facilitating the scheme. And then comes the most disturbing part. In the final segment, Witness 14 recounts threats made against their children. Photos of their kids' school were allegedly sent to their phone with a message reading, "Testimony has consequences." Legal scholars say this escalates everything. Threatening a witness is a serious crime. Threatening their children elevates it to the most severe level of federal witness intimidation, carrying enhanced penalties. The full recording runs 47 minutes. Analysts estimate that over half contains directly incriminating testimony. The audio quality is reportedly crystal clear. No edits, no gaps. Multiple forensic experts have confirmed the recording's authenticity. Voice analysis matches prior verified samples. Metadata aligns with the claimed date. References inside the tape have been independently corroborated. Sources confirm Judge Caldwell personally listened to the entire recording twice before issuing her orders, pausing only to consult statutes with her clerks. Those who've heard the audio say the transcripts don't fully capture its impact. The fear in the witness's voice, the exhaustion, the resignation of someone who knows they've risked everything. One journalist described it as 47 minutes that could redefine this case, and possibly the era of American justice itself. What makes this situation truly extraordinary isn't just what's on the recording, it's how the court reacted once it was confirmed. According to multiple sources inside the federal courthouse, Judge Eleanor Caldwell didn't hesitate. After authentication experts verified the tape, she immediately reviewed it herself from start to finish. She didn't call for a briefing. She didn't wait for motions. She acted. Within hours, arrest warrants were drafted, signed, and transmitted directly to the U.S. Marshals Service. Former prosecutors say this speed is almost unheard of. Federal courts are built on deliberation and process. But this moment shattered the usual timeline. The names listed on those warrants reportedly stunned everyone in the room. These were not low-level participants. These were individuals with power, resources, and connections, people widely assumed to be untouchable. And the marshals sent to execute those warrants weren't local deputies. They were federal agents, pulled from multiple jurisdictions, operating under direct judicial authority. So why such urgency? Because the tape doesn't describe past misconduct alone. It outlines actions that were still unfolding. According to legal experts reviewing the transcripts, Witness 14 describes an active effort to interfere with the case while it was still under investigation. Evidence destruction wasn't hypothetical. It was ongoing. Witness intimidation wasn't implied. It was deliberate. The recording reveals that after subpoenas had already been issued, coordinated steps were taken to eliminate physical and digital records. The witness describes hard drives being wiped using specialized software, paper files destroyed in multiple locations, and backup systems purged to eliminate recovery options. What makes this testimony especially dangerous is how detailed it is. The witness doesn't rely on memory gaps or assumptions. They describe who gave the instructions, where the actions took place, and how compliance was monitored. Legal analysts say this level of specificity drastically reduces the defense's ability to argue ambiguity, but the case doesn't stop at obstruction. Witness 14 also explains how false testimony was coordinated. According to the recording, individuals were provided with talking points, not suggestions, but scripts. The witness claims they were told exactly how to answer specific questions and warned never to deviate. At least 4 people were allegedly involved in synchronizing their stories. And then there's the money. The tape describes a series of cash payments delivered in stages, not wire transfers, not traceable checks. Physical cash totaling more than $340,000. According to the witness, the payments were explicitly tied to silence, to ensuring certain people remembered things correctly or didn't testify at all. Legal experts say this alone constitutes multiple federal felonies, but the most chilling portion of the recording centers on coercion. Witness 14 recounts how hesitation was met with intimidation, not vague warnings, explicit threats. The witness describes being told that non-compliance would bring consequences not just for them, but for their family. The threat escalated when photos were sent to their personal phone, images of their children's school, images taken recently, along with a single message, "Choices have consequences." Experts say this transforms the entire case. Threats against a witness are serious. Threats against their children elevate the charge to the most severe category under federal law, carrying enhanced penalties and mandatory sentencing considerations. This wasn't pressure. This was terror, and Judge Caldwell appears to have understood that instantly. According to sources present during the emergency session, the judge was visibly shaken, not by the leak itself, but by what the recording revealed. She reportedly stated that allowing even a single day of delay could result in further harm, further evidence destruction, or worse. That's why she didn't wait. By dawn, the courthouse was effectively sealed. Entry points were locked down. Marshals positioned themselves throughout the building. Attorneys arriving for the emergency session were ordered to surrender their phones. No press was allowed inside. No public observers, only essential personnel. By the time Judge Caldwell took the bench, the room was silent. She reportedly opened with words that stunned everyone present. "In over 2 decades on this bench, I have never encountered obstruction this explicit, this organized, or this brazen." Then she began reading the names. One by one, 4 individuals were identified. Arrest warrants signed, orders sealed. When she finished, she issued a warning directly to the courtroom. Any officer of the court, including attorneys who had knowledge of these activities and failed to report them, could face their own legal consequences. The impact was immediate. 2 defense attorneys reportedly attempted to withdraw from the case on the spot. Both requests were denied. That's when it became clear this wasn't just a case unraveling. This was a federal judge drawing a line and ordering the full force of federal law enforcement to enforce it. The emergency courtroom session marked a turning point. But what followed sent shockwaves far beyond that building. Within minutes of the arrest warrants being signed, U.S. Marshals began executing coordinated operations across multiple locations. This wasn't symbolic. This was enforcement. By mid-morning, 2 of the 4 individuals named in the warrants were already in custody. A third was detained at a private airstrip roughly 90 miles from the nearest international border. According to law enforcement sources, that individual was traveling with multiple suitcases and a large amount of undeclared cash. The 4th suspect remains unaccounted for. The Marshals Service issued a public advisory confirming that the individual may have fled the jurisdiction. Federal authorities are now coordinating with international partners to track possible exit routes. Inside legal circles, this development confirmed what many had already concluded. Judge Caldwell's decision wasn't precautionary. It was necessary. By early afternoon, confirmation emerged that Witness 14 had been relocated once again. Their protective detail was doubled. All external communication was suspended. According to sources familiar with the protection program, the threat level had escalated dramatically after the leak. The recording itself, despite aggressive takedown efforts, continues to circulate widely. Legal analysts acknowledge the obvious problem: jury contamination. With the audio spreading across platforms and private channels, finding an untainted jury pool may prove nearly impossible. Defense teams are already preparing venue change arguments. But here's the complication. This case has now gone national. There may be no untouched jurisdiction left. Judge Caldwell appears fully aware of this reality. According to courthouse sources, she weighed that risk and concluded it was secondary to preventing further harm. The integrity of the process, she reportedly stated, cannot survive if witnesses are being hunted and evidence erased in real time. By late afternoon, the judge scheduled an initial appearance hearing for the following morning. Prosecutors are expected to argue for detention without bail, citing explicit threats, evidence destruction, and clear flight risk. Legal observers say the bail hearing alone could reshape the entire case, but the fallout didn't stop with the arrests. Within hours, attorneys for one of the accused released a statement attacking the judge's decision. They labeled the action an abuse of power driven by illegally obtained evidence. What the statement notably did not do was address a single allegation described in the recording. No denial of meetings, no explanation for the payments. No response to the threats. Instead, the defense focused entirely on how the tape became public. Legal communications experts were quick to point out the flaw. When a response attacks the source but avoids the substance, it often signals that the substance is indefensible. Other defense teams chose silence. No statements, no press conferences, no denials. According to former prosecutors, this silence may indicate one of 2 things: ongoing negotiations or an acknowledgement that public statements would only worsen the situation. And then there's the legal exposure extending beyond the defendants themselves. The recording allegedly references legal counsel facilitating witness coordination. If verified, this could open a second front: ethics violations, disbarment proceedings, and even criminal charges against officers of the court. Bar associations in multiple states have reportedly initiated preliminary reviews. The American Bar Association is monitoring developments closely. This case is no longer confined to a courtroom. It's now testing the entire legal system. At its core, this isn't just about obstruction or intimidation. It's about whether justice can function when powerful individuals attempt to bend it through fear, money, and silence. Witness 14 didn't leak the tape. They entered protective custody. They testified under oath. They trusted the system. Someone with access betrayed that trust, but that betrayal exposed something far more dangerous, a sustained effort to corrupt the judicial process itself. Months of intimidation, coordinated false testimony, threats against children. Judge Caldwell's response represents a line being drawn. It signals that obstruction will no longer be treated as a secondary issue, something to be dealt with later, but as an immediate threat demanding immediate action. Legal historians are already calling this moment a potential inflection point. If other judges follow this approach, it could fundamentally change how obstruction cases are handled nationwide. For years, critics have argued that delay tactics allow well-resourced defendants to outlast accountability. This case challenges that assumption. Here, the court moved first, and now everything hangs in the balance. As of this moment, the situation is still unfolding, and the consequences are accelerating by the hour. Federal Marshals have now confirmed that 3 of the 4 individuals named in Judge Caldwell's arrest warrants are in custody. The 4th remains at large, prompting an expanded multi-agency manhunt. According to law enforcement briefings, the 3rd arrest occurred under circumstances that raised immediate red flags. The suspect was intercepted at a private airfield, traveling with multiple bags and tens of thousands of dollars in cash. No destination was officially filed. Authorities believe the timing suggests an attempt to flee. Judge Caldwell responded swiftly. An initial appearance hearing has been scheduled for tomorrow morning at 9 a.m. Eastern. Prosecutors are expected to argue forcefully against bail, citing the attempted flight, documented threats against a protected witness, and the ongoing risk of obstruction. Legal experts say pretrial detention is now highly likely. Meanwhile, Witness 14 has been moved yet again. Their location remains classified. Protective measures have been intensified, and all outside contact has reportedly been cut off. Sources close to the protection program say the decision reflects a serious escalation in perceived danger. The recording itself continues to circulate despite removal efforts. Legal analysts acknowledge that its spread has permanently altered the landscape of the case. Defense attorneys are preparing arguments for venue changes, but with national exposure, finding an unaffected jury pool may be impossible. Judge Caldwell appears unmoved by that reality. According to those familiar with her thinking, she views jury complications as a future problem, one that cannot outweigh the immediate threat posed by intimidation, evidence destruction, and active obstruction. The broader legal community is now watching closely. Former prosecutors, constitutional scholars, and judicial historians are calling this a defining moment, not because of the allegations alone, but because of the response. For decades, obstruction cases have followed a familiar pattern: delay, motions, procedural battles, witnesses intimidated quietly, evidence lost slowly, accountability diluted over time. This case broke that pattern. Judge Caldwell treated obstruction not as a secondary charge, but as an emergency, a threat to the system itself, and she acted accordingly. Experts say this approach could mark a shift in judicial culture. If other judges follow this model, defendants may no longer be able to weaponize delay or intimidation to escape consequences. The message is unmistakable: interfere with justice, and the court will intervene immediately. The defense response has only intensified scrutiny. Instead of addressing the facts, the meetings, the money, the threats, public statements have focused on attacking the process and the judge herself. Legal analysts warn this strategy may backfire. Accusations of bias, when unsupported, can be interpreted as deflection. Courts tend to view such attacks as a sign of desperation, not strength. More telling is what hasn't happened. No one has denied the cash payments. No one has disputed the dates. No one has explained the photographs sent to a witness's phone. Silence, in this context, speaks loudly. Beyond the courtroom, this case now carries a deeper significance. It raises a fundamental question: can the justice system protect those who risk everything to tell the truth? Witness 14 stepped forward under oath, entered protection, trusted the process, and someone betrayed that trust by leaking sealed evidence. But that betrayal exposed something far more dangerous: a coordinated attempt to corrupt justice through fear. Judge Caldwell's response signals a refusal to accept that outcome. It asserts that witnesses will be protected, that intimidation will be punished, and that courts are not powerless when confronted with organized obstruction. In the coming days, plea negotiations may begin. Additional arrests are possible. More evidence could surface. The case may expand beyond what anyone initially imagined, but one thing is already clear. This is no longer just a legal battle. It's a test of whether the system can still act decisively when it matters most. And for now, the system is moving. Arrests are being made. Hearings are scheduled. Lines have been drawn. What happens next will determine whether this moment becomes a turning point or a missed opportunity. Stay alert. The next 48 hours could redefine everything.